A federal judge just dropped the hammer, and this time there is no appeal, no delay, no political maneuver that can stop what is coming. Judge Arthur Ongaron of the New York Supreme Court has revoked Donald Trump's bond arrangement in the civil fraud case, issuing an emergency order on February 26th that sends shockwaves through every corner of American law, politics, and finance. The ruling is simple and brutal. Post $464 million in cash, not assets, not collateral, not promises, within 10 days, or face the immediate seizure of some of the most iconic real estate properties in the United States. Hit that subscribe button right now because what I'm about to walk you through is the single most consequential legal moment in the history of the American presidency. This isn't a fine. This isn't a slap on the wrist. This is a constitutional reckoning unfolding in real time. And the clock is ticking. Sources inside the New York Attorney General's office, speaking on condition of anonymity, told reporters late Thursday night that enforcement teams were already being briefed on asset identification protocols. Let that sink in. Before the ink was even dry on Judge Ongaron's order, the machinery of enforcement was already spinning up. When the government starts preparing to physically seize properties before a deadline has even passed, you know something historic has just detonated. So, let's start at the beginning because to understand why this ruling is so extraordinary, you need to understand what led here. Back in February 2024, Judge Ongaron issued his original judgment, $364 million in the fraud case, which ballooned to $464 million with acre-wing interest. The case centered on years of alleged financial fraud in which Trump's organization was found to have systematically inflated property values to secure loans and deflate them to reduce tax liability. The judge found this conduct, quote, persistent and pervasive. Language that legal analysts called unusually blunt for a civil ruling of this magnitude. Trump's legal team scrambled. They sought a reduced bond, eventually securing a $175 million bond through Knight Specialty Insurance Company. But here's where the story turns, and here's where it really gets serious. On February 19th, just 1 week before Judge Ongaron's emergency ruling, investigators from the New York Attorney General's office submitted a sealed filing, raising grave concerns about the legitimacy of that bond. Sources familiar with the filing told the New York Times that investigators had uncovered what they described as, quote, serious irregularities in Knight Specialty's financial documentation. The bonding company investigators alleged lacked the liquid assets to back a bond of this size. In plain English, the bond that Trump posted to delay paying $464 million may have been essentially worthless. A piece of paper backed by nothing. Smash that like button if this is making sense so far, because we are just getting started. When Judge Ongaron reviewed that sealed filing in a closed emergency session on February 25th, a session that lasted 4 hours, according to court staff who spoke anonymously to Reuters, he reached a conclusion that shook the legal community. The bond was invalid. The protection it offered was illusory. And under New York civil enforcement law, that meant the original judgment was immediately enforceable. The stay was gone. The clock reset, and the number on the table was 464463-218. Every penny of it due in cash, certified funds, or equivalent liquid assets within 10 days. That ruling landed publicly on the morning of February 26th, and Washington has not been the same since. Don't go anywhere. The most explosive part is coming next. Let me tell you what $464 million actually means in practical terms, because the numbers alone don't tell the whole story. According to financial disclosures filed in connection with the fraud trial, Trump's verified liquid assets, cash, money market accounts, verified securities, total somewhere between $115 and $165 million, depending on which filing you review and which valuations you accept. That is less than half of what the court is demanding, which means that if Trump cannot raise the remainder through emergency financing, asset liquidation, or some other mechanism within 10 business days, the New York Attorney General is legally empowered to begin seizing and auctioning properties to satisfy the judgment. And what properties are we talking about? Sources inside the Attorney General's Enforcement Division, speaking to the Washington Post on background, identified the likely first targets. 40 Wall Street, the landmark Manhattan skyscraper that Trump has owned since 1995. 7 Springs, the 212-acre Westchester County estate, the Trump Organization's commercial properties in Manhattan, and potentially, those sources say this is considered a last resort, portions of the Mar-a-Lago property itself, pending complex jurisdictional questions involving Florida law. A former assistant attorney general for New York speaking on CNN on the morning of February 26th put it bluntly. This is not theoretical anymore. The enforcement mechanism is real. It is ready, and it will be used if that money is not posted. Drop a comment right now with your thoughts. I read every single one. Now, here is where the constitutional dimensions of this case become impossible to ignore, because what we are watching is not just a financial dispute. It is a direct test of whether the rule of law in America applies equally to a former president who is also the current leading candidate in a presidential race. That question, that fundamental bedrock American question, is now sitting in the hands of a New York judge, an enforcement division, and ultimately the courts of appeal that will or will not intervene. Trump's legal team filed an emergency application to the appellate division on the afternoon of February 26th, asking for an immediate stay of enforcement pending appeal. The application, which runs 47 pages, argues that Judge Engoron's revocation of the bond exceeded his authority, that the sealed filing from the Attorney General's office was procedurally improper, and that enforcement actions against a presidential candidate constitute an unprecedented intrusion of the judiciary into the democratic process. Legal experts who reviewed the filing were divided. Several prominent constitutional law scholars told Politico that the arguments, while creative, faced an uphill battle. One Harvard law professor who has argued before the Supreme Court said the application contained, quote, legitimate procedural arguments buried under political rhetoric that courts are unlikely to find persuasive. And here is why that assessment matters. The appellate division has historically been reluctant to grant emergency stays in civil enforcement actions where a final judgment has already been upheld through the normal appellate process. The legal window for relief is narrow. The time frame is tight, and the clock, that 10-day clock, does not pause while courts deliberate. Subscribe immediately if you haven't yet. This content does not exist anywhere else. Let's talk about the political earthquake because it is happening simultaneously with the legal one. Republican leadership in Washington spent the morning of February 26th in what multiple sources described as a state of controlled panic. Senior party strategists held emergency conference calls beginning at 7 o'clock a.m. Eastern Time, scrambling to develop messaging that would simultaneously defend Trump, attack the New York judiciary, and somehow contain the political damage of a former president facing property seizure during an active campaign. The challenge is nearly impossible. Here's why. Every campaign surrogate sent to defend Trump on television faces the same impossible question. If your candidate cannot post $464 million in a civil fraud case, how does the public trust him with the finances of the United States government? That question has no good answer, and Republican operatives know it. Meanwhile, Democratic strategists told The Hill that campaign ads are already in production. Multiple sources described footage being compiled of Trump's most famous properties, the gold lobbies, the marble interiors, the branded towers, alongside text reading, "What happens when the bill comes due?" Those ads, sources said, are expected to air in swing states within 72 hours of any enforcement action beginning. Don't go anywhere, because what comes next will completely change how you view the stakes of this moment. Here's what should alarm everyone regardless of party. This case was never really about Donald Trump. It was always about whether powerful people, people with access to top lawyers, top accountants, and top political connections face the same consequences as ordinary Americans when courts find them liable for fraud. Because here is the math that middle-class Americans understand immediately. If you lie on your mortgage application, you lose your house. You may face criminal charges. You certainly pay back the money. The question this case poses to the American legal system is whether that same math applies when your name is on the building. Judge Engoron answered that question on February 26th. His answer was yes. A former federal prosecutor speaking to MSNBC on Thursday evening framed it this way. Enforcement of a civil judgment is not political prosecution. It is not a witch hunt. It is the final step in a legal process that has already been affirmed by every court that has reviewed it. The machinery of the law is doing exactly what it was designed to do. And yet the political response has been volcanic. By midday on February 26th, Trump himself had posted more than 24 times across social media, calling the ruling a weaponized attack, describing Judge Engoron as a radical left lunatic and alleging without evidence that the sealed filing from the Attorney General was based on fabricated financial data planted by, in his words, deep state operatives working directly with the Biden-Obama machine. He named 3 specific appellate judges by name, warning them publicly that their rulings would be remembered. Legal analysts noted immediately that those public statements could themselves become relevant in future proceedings. If enforcement actions proceed and Trump makes statements that appear designed to intimidate judicial officers, that opens an entirely separate legal exposure under New York Judiciary Law Section 750, which governs contempt of court in civil proceedings. If this is blowing your mind, hit that like button right now. Let me tell you what happens in each of the scenarios we are now looking at. Because this story does not have one ending, it has several, and they all matter. Scenario 1. Trump successfully posts the full $464 million in cash or verified liquid assets before the 10-day deadline. This is considered the least likely outcome by financial analysts who have reviewed the public disclosures, but it is legally the cleanest. It buys time for the appellate process to proceed. It removes the immediate enforcement pressure, and it allows Trump to continue arguing the underlying judgment was wrong. The political cost, however, is enormous. Posting nearly $500 million from personal funds while running for president raises questions about financial capacity that campaigns do not want circulating. Scenario 2. The appellate division grants an emergency stay. Multiple legal sources put the odds of this at roughly 30%, citing the narrow legal grounds in the emergency application and the appellate court's historical reluctance to intervene in civil enforcement. At this stage, if a stay is granted, enforcement is paused. The political pressure drops temporarily, and the case returns to the slower rhythm of appellate review. But the underlying judgment and the underlying question of whether that bond was real remains unresolved and potentially more damaging if it surfaces again. Scenario 3. No stay is granted. Trump cannot post the cash and enforcement begins. This is the scenario that sources in both legal and political circles describe as the most likely if no breakthrough occurs in the next 72 hours. New York Attorney General Letitia James' office moves to identify, appraise, and auction assets. Properties begin changing hands. The legal and political spectacle that follows is by any measure without precedent in American history. A sitting appeals court judge in New York, speaking anonymously because active judges cannot comment publicly on pending matters, told a colleague who shared the remark with a legal journalist, "We are in territory the law books do not cover." Drop a comment below with your reaction. I am genuinely curious to see your perspective. But beyond the scenarios, beyond the politics, beyond even the specifics of this case, there is a deeper American story being told right now. And it is one that voters aged 45 and older understand in their bones because they have spent their lives watching the law be applied selectively, leniently for the powerful, harshly for everyone else. What Judge Engoron's ruling represents at its most fundamental level is the proposition that the law is not selective. That $464 million is $464 million whether your name is John Smith or Donald Trump. That fraud is fraud whether it is committed in a subprime mortgage application or in a skyscraper valuation document submitted to Deutsche Bank. The American constitutional order was designed precisely for moments like this one. The founders, who were acutely aware of the danger of powerful men placing themselves above the law, built a judicial system intended to be immune to political pressure. Article 3 federal judges serve for life precisely so they cannot be punished at the ballot box for unpopular rulings. State judges like Arthur Engoron operate under different rules, but the principle is the same. The law must be applied without fear or favor. What happens in the next 10 days will tell us whether that principle still holds. Stay with me because what happens next affects every single one of us. Here is where things stand as of this moment. The 10-day clock on Judge Engoron's enforcement order is running. Trump's legal team has filed an emergency stay application with the appellate division. Financial advisors are reportedly working around the clock to identify, whether any emergency financing mechanism exists that could cover the gap between Trump's verified liquid assets and the $464 million demand. Sources familiar with those conversations say at least two major financial institutions contacted in the past 48 hours declined to participate, citing reputational risk and regulatory exposure. Meanwhile, the New York Attorney General's Enforcement Division has completed its asset mapping. Appraisers have been briefed. Option protocols have been reviewed. Sources say the office is, in the language of one insider, ready to move at midnight on day 10 if necessary. Military families in this country understand something about duty and consequence that Washington sometimes forgets. You take an oath. You bear the responsibility. You face the outcome. The same principle that governs service in uniform governs service in office, in business, in life. You cannot inflate your worth when it benefits you and deflate it when the bill arrives. The law at its best, at its most fundamental, exists to ensure that principle is enforced. A former United States attorney speaking on Fox News, a note on Fox News, said something that stopped the anchor mid-sentence. He said, "I've prosecuted fraud cases for 20 years. The facts in this judgment, if accurate, are not close calls. They are textbook violations. The only question now is enforcement. And in America, we enforce judgments." That moment, a conservative legal voice on a conservative network saying plainly that the law is the law may be the most significant 20 seconds of television produced in this entire saga. Before we go any further, smash that subscribe button so you never miss coverage like this. Here's the final picture. A judge has ruled, a bond has been voided, a deadline is running, and a former president, who may again be a future president, is facing the most consequential financial reckoning in the history of American politics. The implications extend far beyond one man and one case. If enforcement proceeds and properties are seized, it establishes beyond any doubt that no individual, regardless of political power, name recognition, or legal firepower, stands above the reach of a civil judgment in this country. That precedent once set cannot be undone. It becomes part of the fabric of American law referenced in courtrooms for generations. If enforcement is blocked, whether by emergency stay, by political pressure, or by some other mechanism, the signal sent is equally powerful and far more troubling that sufficiently powerful defendants can delay, obstruct, and ultimately avoid consequences that ordinary Americans cannot escape. That is the precedent no court should want to set, and no honest legal analyst thinks serves the long-term interests of the rule of law. The stakes have never been higher. The legal machinery has never been more engaged, and the next 10 days will determine whether the words carved above the entrance to the United States Supreme Court, equal justice under law, are a promise or a marketing slogan. $47 billion in publicly documented real estate, $464 million owed. 10 days on the clock. One judge's order standing between the way things have always been and the way the law says they must be. We are watching. The country is watching. And history is taking notes. Pause for a second and hit that like button if you found value in this coverage, and drop a comment telling me which scenario you think plays out. I read every single response, and right now your voice on this matters more than